Good evening. I am Carol Allman-Morton, the Executive Director of the Osher Lifelong Learning Institute at Berkshire Community College. We are a community of people 50 years old and better, committed to learning and having fun in community. If you would like to learn more about programming at OLLI at BCC, you can check out our website, and I'm going to put that in the chat. And I invite you to join us again next week for a free and open to the public lecture, Ukraine, Russia, and the West, the Outlook for 2023, a discussion with former New York Times foreign correspondent and Ukraine reporter James Brooke. That is Wednesday, February 22nd at 7 p.m. Eastern Time, and that is free and open to all. You are welcome to register, share the link, bring your friends. Should be a great time. Also, our spring course listings will be posted next week. So if you've been waiting with bated breath, they are coming soon. All right, but that's not what we're here for tonight. Tonight, we welcome this evening's lecture, Worse Than Nothing, The Dangerous Fallacy of Originalism. All of our programs are volunteer driven, and we are so grateful for all the folks who make programs like the one tonight happen, including Doug Mishkin, who I'm going to turn things over to. Doug is a frequent OLLI teacher and speaker. And take it away, Doug. Thank you.
Welcome. I had a professor in law school who preached that to gain advantage in litigation, you give me the procedure, I'll give you the substance. Namely, the process by which a case is decided frequently goes a long way toward dictating the outcome. You give me the procedure, I'll give you the substance. In thinking about how the Supreme Court addresses substantive issues that you may care about, it's important to look at the process by which the court reaches its results. Our program today is about the process that a growing number of Supreme Court justices and other judges use or purport to use in interpreting our Constitution. They call their theory of interpretation originalism. Our guest says originalism, quote, is not a theory of judging at all, but only a rhetorical ploy to make it appear that decisions are based on something other than political ideology. He calls originalism, quote, an emperor with no clothes, end quote. It is, he says, not merely a fallacy, but a dangerous fallacy. Erwin Chemerinsky is the Jesse H. Chopra Distinguished Professor of Law and the Dean of the Berkeley Law School of the University of California at Berkeley. He is a longtime distinguished public intellectual, engaging the public in an ongoing seminar about the Constitution and how all too often our rights are eroded rather than protected by the courts and the Supreme Court in particular. I suspect some of you are familiar with at least some of his work. To those of you for whom this is your introduction to Professor Chemerinsky, I have two words for you. You're welcome. Today's subject is his recent book, Worse Than Nothing, The Dangerous Fallacy of Originalism. Erwin Chemerinsky, thank you so much for joining us.
Thank you for the kind introduction, and thank you for inviting me.
Well, it's a pleasure to have you. And what I'd like to do as best we can is to go almost chapter by chapter so that we at least touch upon each of your arguments that originalism is a dangerous fallacy. With our time constraint, I'm sure that we'll do each chapter something of an injustice, but let's get started. What is originalism, or at least what do originalists say that it is?
Original is the view that the meaning of a constitutional provision is fixed when it's adopted and it changed only by a constitutional amendment. So the First Amendment or the Second Amendment mean the same thing today as they did in 1791. The Equal Protection Clause of the 14th Amendment means the same thing as it did in 1868. That for an originalist, constitutional interpretation is about finding the original meaning of a constitutional provision, and nothing else is relevant.
Now, you describe in the book how even that definition of originalism has shifted a bit over time. Talk a little bit about how we went from original intent versus original meaning.
Originalism began in the 1970s as a way for conservatives to criticize the liberal rulings of the Warren Court. If there's any seminal article, it was in 1971 by a Yale law professor, Robert Bork, followed by a book called Government by Judiciary by Harvard professor Raoul Berger. What really fueled the development of originalism theory was Roe versus Wade. Conservatives attacking Roe versus Wade latched onto it as a way of saying that the Supreme Court was wrong. As originalism was initially put forth by people like Robert Bork and Raoul Berger, it was about finding the framers' intent, and that's what should govern the meaning of a constitutional provision today. But critics pointed out all the problems with trying to determine the framers' intent. I mean, the framers often disagreed among themselves. I like to point out to my students in constitutional law how often Hamilton and Madison disagreed. So many people were involved in drafting or ratifying a constitutional provision that there wasn't an intent to be discovered. And of course, often for the issues that we're thinking of today, there was no framers' intent. They didn't think about the issue. Well, as a result of all the criticism, originalists shifted and said, we're not going to look at the views of the framers, but instead the task is going to be to determine the original public meaning of the language in the Constitution. But I should here offer a note of caution. There are times that the Supreme Court continues to still look to framers' intent originalism. As recently as June 27, 2022, in a case called Kennedy versus Bremerton Schools that involved whether a high school football coach could go onto the field and pray, Justice Gorsuch, writing for a 6-person majority, including all the originalists on the court, said, we determine what violates the Establishment Clause of the First Amendment, the provision that we know establishment of religion, by looking at, quote, the founding fathers' views. So that was framers' intent originalism just several months ago.
You talk a bit about the originalist justices, or Justice Barrett, for example, who says when it comes to relying on precedent versus determining the constitutionality of a provision, the judicial oath is to uphold the Constitution, precedent be damned. Can you talk for a moment or two about that?
Justice Clarence Thomas is most famous for saying this. He has repeatedly said that precedent should be given no weight in constitutional law. That in every case, the court should discover the original meaning. If the original meaning is different from prior decisions should be overruled. And he's willing to take this fairly radical direction. He has said that New York Times versus Sullivan, the 1964 case that limited the ability to sue for defamation if you're a public official, should be overruled. He said that Gideon versus Wainwright, the 1963 case that says the government and state court has to write a free attorney if someone can't afford one, he would overrule that. Last June, Justice Thomas gave a speech in Atlanta where he said, following precedent is just an excuse for laziness. We should always follow the original meaning. Well, as you point out, when she was a law professor at Notre Dame, Amy Coney Barrett wrote a couple articles where she also took that position, saying with the conflict between the original meaning and precedent, the original meaning should control, precedent deserves no weight.
What do you, as a non-originalist, say about the weight that precedent should be given if you think there's some conflict between it and the constitutionality of a provision?
There's long articles, books written about precedent, or as it's called in the law, stare decisis, and they always come to the same conclusion. Precedent should be followed except when it should be overruled. And of course, that's got to be the answer, because precedent is important. It provides stability, predictability to the law. On the other hand, there's times where it's imperative that precedent be overruled. It was essential that Plessy versus Ferguson overruled Brown versus Board of Education. And so I think the Supreme Court overruling Roe versus Wade last June 24th was they're giving no weight to precedent. On the other hand, if there were a liberal majority, they might well have overruled Citizens United versus Federal Election Commission.
you talk in the opening chapter about originalism as having originally, or originalists originally having justified originalism in the name of judicial restraint. And you talk about how judicial restraint and judicial activism cut in different directions. Can you talk for a moment about that?
After the Warren Court, conservative critics very much adopted the mantra of, we favor judicial restraint, they're judicial activists. Now, if you look at how the language is used, I think judicial activism is just a label attached to the decisions that someone doesn't like. But if we were to try to come up with a principled way of talking about what's judicial activism, we could say, well, when the court defers to the political process, it's more restrained. When it overrules, it's more activist. When the court follows precedent, it's more restrained. When it overrules precedent, it's more activist. When the court rules narrowly, it's more restrained. When it rules broadly, it's more activist. What we see now is that the Supreme Court, in the name of originalism, is being very activist. I mean, think the decision last June, on June 23rd, New York State Rifle and Pistol Association versus Bruin, that said that there's a constitutional right of people to have guns in public, even concealed weapons, striking down New York law adopted in 1907. The court was overruling a longstanding law. The court was overruling decades of precedent, and the Supreme Court ruled very broadly. Or another important case, Shelby County versus Holder in 2013, where the court declared unconstitutional a key provision of the Voting Rights Act of 1965. There was no judicial restraint there, overturned an important federal law, overturned precedent, ruled very broadly. I can go on and on with examples. My point is that now conservatives are using originalism to do all of those things, to overturn precedent, to overturn decisions of popularly elected legislators, to rule broadly rather than narrowly. And so you don't find conservatives any longer using the mantra of judicial restraint.
So you point out Justice Scalia was one of the early foremost proponents of what he called originalism. And the argument by Scalia was, in effect, we originalists have a theory, you guys have none. Talk about that a bit, would you?
Justice Scalia was fond of saying that, and fond of just the words you used, and fond of saying a theory always beats no theory. That's what led to the title of my book, Worse Than Nothing. Because if it's a bad theory, it really is worse than nothing. If it leads to terrible results, as I think originalism does, it's hardly a defense to say, but it's a theory.
So with that as a point of segue, let's move on. What I want to do is to address the next 5 chapters of the book, because in each one you identify a particular category of problem with originalism. I want to see if we can hit each one at least briefly.
Sure.
The first of the 5 problems you call the epistemological problem. Namely, it's simply impossible to know what the framers meant when it comes to the crucial clauses of the Constitution. And I want to point out to our listeners, for what it's worth, this is, in my view, far and away the most entertaining chapter of the book. And it's entertaining because you draw on your experience from 25 years ago, when apparently you lost your mind for a while and ran for the Los Angeles City Charter Commission, which then you chair. And the commission was charged with drafting a new city charter. And as you say, it was an exercise in constitution drafting. I'd love to hear from you. I want our listeners to hear how that experience helped inform your view of originalism as a fallacy.
I'm so glad you liked that chapter. I went back and forth on whether to include the story you referred to in the book. And so it's so good to hear that you found it useful. You describe it well. In California, and this is true in many states, charter cities have a charter, and it's the governing document. In California, It allocates powers among the branches of the government. In Los Angeles, there's the city council, the mayor, the city attorney, the city controller elected. It prescribes aspects of the procedure for the operation of city government. It can provide more protection of rights than the US Constitution or state law. Los Angeles' charter was written in 1925. It had been amended 400 times. Make a long story short, there was consensus that Los Angeles needed a new charter, but no agreement on how to do it. One way of having a new charter is for the voters to pass an initiative to create an elected commission, and the elected commission can put whoever it wants on the ballot. There are 15 city council districts in Los Angeles. Each was to elect one representative to a 2-year unpaid term to draft a new charter to put on the ballot in June of 1999. I ran in my council district. I was one of 7 people, and amazingly, I got elected. And then I was chosen by my fellow commissioners to be the chair. And it was an incredibly intense 2-year process. There was no consensus on any issue. In that sense, it was like drafting the US Constitution where there was no consensus. The mayor had very strong views. The city council loathed the mayor, and they had strong views. The unions had their views. The homeowners had their views. And ultimately, we produced a compromise document. The voters adopted it in June of 1999. And almost as soon as it got enacted, an issue arose, and both sides of the litigation called and said, "What did your commission think on this question?" And the answer was, "We never thought about that issue." It went to the court, and the Charter of Los Angeles, about 100 single-spaced pages. That's what went to the voters. And the judge said, well, the voters' intent behind this one obscure sentence was, well, that's a fiction. There was no voters' intent on the issue. No one thought of the issue. It continues. Just as recently as last Thursday, I got an email from lawyers who are litigating an issue in Los Angeles that said, what did the Charter Commission think with this sentence? And I said, it's 25 years ago. I'm not sure I remember, but I don't ever remember our talking about it. We certainly never thought about that issue. What I discovered was when the lawyers liked what I had to say, they would always reply, would you write a declaration saying that? And when they didn't like what I said, they keep calling other commissioners to see if they could find someone to write a declaration. In the years after the charter was adopted, thankfully, all of us were still alive. Some have since passed away. And yet you couldn't have gotten us together and said, we agreed as to most of the issues that were coming up because we never thought of those issues. To me, that so reflects the epistemological problem in a constitution drafting exercise. There were 55 in Philadelphia. There were untold numbers in the 12 ratifying conventions. How are we going to ever know what they thought, especially about issues they never considered?
Let me point out to my fellow residents of the Commonwealth of Massachusetts that at the Constitutional Convention in Massachusetts, where the Constitution was adopted, it was by the overwhelming landslide vote of, I think, 187 to 165. So what the intent was of people in Massachusetts when they were adopting the Constitution, who could say? So I thought your description of never thought about it, intent of the voters is a fiction. It's a very rich story, and I'm delighted you put it front and center in the book. So you then go on to talk about the silence of our federal Constitution on all kinds of issues. Does the president have power to remove cabinet officials? Can the president rescind a treaty? Can you talk a little bit about that?
There are many questions of constitutional law where there is nothing in the Constitution and there was no original meaning because they weren't thought about. You've alluded to some of them. The Constitution says that the president appoints the cabinet with the advice and consent of the Senate. It doesn't have a word about the president removing the cabinet. And yet an enormously important issue arose in the 1860s that was the basis for the impeachment of Andrew Johnson, as to whether or not Congress can limit removal, where the president has the power to remove cabinet officials. Or take executive privilege. Does the president have the ability to keep secret memoranda with, conversations with, advisors? This is what was front and center with regard to the controversy when Richard Nixon was facing impeachment. There's nothing in the Constitution. Or another example you mentioned, the Constitution says the president can negotiate treaties that are effective and ratified by 2/3 of the Senate. But it says nothing about rescinding treaties. President Jimmy Carter wanted to rescind the United States treaty with Taiwan, part of recognizing the People's Republic of China. Did he have the power to do so? President George W. Bush rescinded the United States ABM treaty with Russia. Did he have the power to do that? I'll give an even more basic example. The Constitution doesn't say anything about whether courts have the power to engage in judicial review, reviewing the constitutionality of statutes and executive actions. All of these are constitutional issues. There's no textual language. There's no original meaning to resolve it.
In this chapter on the epistemological problem, you have a subheading on the insurmountable problem of determining the level of abstraction. Can you briefly explain to our listeners what you're talking about there, the problem of determining the level of abstraction?
For any constitutional provision, we can say what it's about in many different ways. Let me take the example of the 14th Amendment that says no state shall deny any person equal protection of the laws. What does it mean? Well, one thing it might mean is it was about protecting former slaves, former enslaved people. Another thing it might mean is just about protecting those who are of African descent. In 1873, in what were called the slaughterhouse cases, the Supreme Court said all it was about was protecting those of African descent. Third thing it might be is we can say, well, no, it's really about protecting all who are people of color, racial minorities. Or another way we could say is it's protect all who are part of historically discriminated against groups. Or we might say that it's about protecting any person from arbitrary treatment by the government relative to others. Justice Scalia said that he believed that it was just about protecting racial minorities. So he believed that there was no protection of women or gays and lesbians from discrimination because he chose that level of abstraction. But it's arbitrary. I gave you 5 different reasonable original meanings of equal protection. Which you choose has real implications, but it is ultimately an arbitrary choice as to which of them should be adopted.
So a large thrust of what originalists claim is that they have a theory, you non-originalists don't, and at least what we're doing is value neutral. Whereas you non-originalists, you're just doing what you want to do. I've put the ball on the tee for you. Can you talk a bit about that?
There's no such thing as value neutral judging. There's certainly many cases where any judge will agree. But when it comes to matters that go to the Supreme Court, there's always 2 sides with strong arguments. Let me give an easy example. The 4th Amendment says there can't be an unreasonable search or arrest. What's unreasonable? How do you decide what's unreasonable in a value neutral way? Or even when there's a constitutional right, the government can interfere with it if the government has a sufficient justification. Let's take the right to be free from race discrimination. The court has said the government can discriminate based on race if its action is necessary to achieve a compelling purpose. Or the government can discriminate on the basis of, say, age, the court has said, if its action is rationally related to a legitimate purpose. But what's a compelling purpose? What's a legitimate purpose? Originalists don't purport to have that answered from an originalist perspective. It's a value choice. And as I'm sure we'll talk about, originalists so frequently abandon originalism when it doesn't get to the result they want. And that too shows there's no such thing as value neutral judging.
Yeah, we'll talk a little more about that in a few minutes. I want to move on. The next chapter, the next problem you identify or category of problem is the incoherence problem. You say, even assuming that somebody could figure out the original meaning of the Constitution, you say there's an incoherence problem. Tell our listeners what you mean by that.
Sure. The easiest way to explain it is that the framers of the Constitution didn't intend that their views would be controlling. It was Chief Justice John Marshall who was one of the framers at Philadelphia, who said, we must never forget it's a constitution we're expounding. Constitution meant to be adapted and endure for ages to come. The official notes of the Constitutional Convention were taken by James Madison, and he directed them not to be published until after his death, because he wanted the Constitution to stand on its own. So if you are an originalist committed to following the framers' intent, the framers didn't want their intent to be followed. And so then I think you have a very elegant argument that following originalism means you have to abandon originalism. Jeff Powell, a professor at Duke, wrote a terrific article in the mid-1980s in the Harvard Law Review titled The Original Understanding of Original Understanding, where he makes this point.
So you slice it as they didn't want, in the chapter, the framers likely didn't want their views to control. And then another point, which you alluded to a moment ago, which is the Constitution itself is silent about the very phenomenon of judicial review. And for our listeners, you know, pretty much since the beginning of the Republic, we've accepted that it's the function of courts to rule on the constitutionality of statutes. Talk a little bit about the originalists' problem with judicial review.
It's hard to know what the framers intended or the original public meaning was as to how judicial review should be done when there's nothing in the Constitution about judicial review. Now, it might be that the framers didn't specify the power of judicial review because they assumed it would exist. It existed in some states before the Constitution, like Pennsylvania. Or it might be they didn't specify because they thought it wouldn't exist. It didn't exist in England. It didn't exist in the Articles of Confederation that preceded the Constitution. It might be that they didn't include it because they just didn't think about it and focus on it. Silence is inherently ambiguous. And so since the Constitution doesn't say anything about the power of judicial review, we can't say then what was the original meaning for how judicial review was supposed to be done.
Right, right. Next chapter, you call it the abhorrence problem. Namely, you come up with a parade of horribles, the results if originalism were to be applied. And you make a statement toward the end, I think maybe is a good jumping off point, where you say a theory must be judged by its real world consequences. Talk a bit about that, would you?
Let me give an example, and then I can come to that statement. Brown versus Board of Education. If anything is the quintessential decision about why we want the Supreme Court, it was Brown versus Board of Education in 1954. It declared that separate can never be equal in public schools, declared that laws that require racial segregation are unconstitutional. It was the beginning of the end of the Jim Crow laws in the United States. Elected Southern judges weren't about to do that. State legislatures in the South weren't going to do that. Congress wasn't about to do that, given especially how much Southerners, the seniority system, controlled Congress and the committee system. And yet, Brown versus Board of Education can't be reconciled with originalism. The same Congress that voted to ratify the 14th Amendment also voted to segregate the District of Columbia public schools. Even originalists admit there's no evidence that Congress in 1868 had in mind ending racial segregation. I would suggest that any theory that makes Brown illegitimate as a decision is a theory of constitutional interpretation we should reject. I could give other examples. Loving versus Virginia, where the court said that states can't prohibit interracial marriage. That can't be justified from an originalist perspective. The prohibition of sex discrimination or sexual orientation discrimination, Justice Scalia said that can't be justified from an originalist perspective. And so to go to the statement that you quoted, my position is that any theory that makes Brown in Loving and the prohibition of sex and sexual orientation discrimination illegitimate isn't a theory of constitutional interpretation that we should follow.
You make a reference to Justice Scalia being confronted with Brown versus Board and his response to the question. Maybe you can share it with our participants.
It's interesting. I was at a conference. It was, I'm ashamed to admit it, at the University of Hawaii Law School. And Justice Scalia agreed to be part of the conference. And he did a program with students prior to the symposium, the program that we were doing. And he took questions from the students. And a student said to him, how do you justify Brown versus Board of Education under your theory of originalism? I'll never forget Justice Scalia's response, and quote it word for word. He said, a broken clock gets it right twice a day. Next question. I have to admit, I thought that was very disrespectful to the student. It wasn't an answer to the question at all, but that was an answer he apparently frequently gave when asked about Brown versus Board of Education.
Yeah, and you quoted him making a reference to waving the bloody shirt of Brown.
Right.
Talk about disrespectful.
He didn't say that at the University of Hawaii, but many other times when he was asked about how he reconciles Brown with originalism, he gave that reply.
So let me ask you this, because I could envision an originalist saying to you, that what you call the abhorrence problem, you're arguing the result is so bad that the interpretation of the Constitution must be wrong. That an originalist would say, well, if the result is so bad, change the Constitution.
And that's exactly what an originalist would say. And yet we have to remember, to amend the Constitution takes a 2/3 vote of both houses of Congress. It also then has to be ratified by 3/4 of the states. The Constitution has been amended only 17 times since 1791. There's an even more important problem here. We're talking about the rights of a minority. Here are the rights of Blacks to not be subjected to the Jim Crow laws that imposed apartheid in so much of the country. It's wrong to say that the rights of a minority will be protected only if a supermajority will protect them. I don't know that we could get a supermajority, 2/3 of both houses of Congress and 3/4 of states today to pass an amendment outlawing segregation. We certainly couldn't in 1954.
Right. Next chapter. You identify what you refer to as the modernity problem, which I calls to mind my beloved political science professor who said, the intent of the framers, these people didn't know what a flashlight was. You begin your discussion of the modernity problem by recounting an argument in the Supreme Court regarding the constitutionality of a California law that prohibited the sale or rental of violent video games to minors without parental consent. Please share with our listeners Justice Scalia's question that was asked, and then Justice Alito's comment about that question. This, by the way, found on my list, it's the second most entertaining part of the book.
Justice Scalia was very much pushing the lawyers in terms of the original meaning of the First Amendment. And then Justice Alito interrupted and said, what Justice Scalia really wants to know is what James Madison thought of violent video games. And of course, it's an absurd question. I mentioned to you a case from last June, Kennedy versus Bremerton Schools, where the court said that it violated the free speech and free exercise religion rights of a high school football coach to punish him for going on the field and praying, including with students. And I mentioned to you that Justice Gorsuch said, we determine what's an impermissible established religion by looking at the views of our founding fathers. Well, then what that means is we need to know, what did the founding fathers think about high school football coaches going on the field and praying after games at a public school? Well, it's absurd. I mean, there weren't public schools. There wasn't high school football. How are we going to answer that question? I mean, I can talk about this in the context of many constitutional provisions. There's no analog. How are we going to know what the framers thought about wiretapping or the police gathering cellular location information. I mean, the question is, or what did the framers think about AR-15s under the Second Amendment?
So you point out in this chapter, you say there are at least 3 issues on which there can be no original understanding. The Fourth Amendment, surveillance technology that you just referenced. Say the growth in the country's size and the complexity that changes the way we must be governed. And then you say how free speech applies to media in the 21st century. I'd like you to take a moment or two and run with one of those, whichever is of interest right now.
Sure. Let me take the last of them because obviously it affects all of us. How are we going to know what the framers of the First Amendment thought with regard to government regulation of social media? The idea of social media was so impossible to imagine, even in our lifetimes, let alone the lifetimes of those in 1791. When movies were first developed, and I make this point in the book, the Supreme Court said that movies had no First Amendment protection. And it took decades before the Supreme Court was willing to say that government regulation of movies raised First Amendment questions. Well, it can't be that because the medium didn't exist in 1791, the government can regulate it however it wants. Whatever our view of social media, however we want it to be regulated, the answers aren't going to be found in the framers' intent from when the First Amendment was adopted.
The last of the 5 chapters that address particular categories of problems that you identify, you call the hypocrisy problem. What's the hypocrisy, Erwin?
Originalists don't follow originalism when it doesn't get to the result they want to come to. They're willing to abandon originalism to come to the results they choose. I can give easy examples of this. Take Citizens United versus Federal Election Commission. The Supreme Court, with the originalists in the majority, held that corporations have the right to spend unlimited amounts of money in election campaigns to get the candidates they want elected or defeated. You can't justify that from an originalist perspective, and yet they would do. Shelby County versus Holder. The Supreme Court said that requiring that jurisdictions with a history of race discrimination in voting get pre-approval before significant change in the elective system violates the principle of equal state sovereignty. There's no principle of equal state sovereignty in the Constitution. There's none in the original meaning of the 14th Amendment or 15th Amendment. The Congress that ratified the 14th Amendment passed the Reconstruction Act and created military rule of the South. Or to focus on an example of cases that are decided this spring by the Supreme Court, affirmative action. I think it's clear that the Congress that ratified the 14th Amendment meant to allow what we today call affirmative action. They adopted many race-conscious programs to benefit those of African descent. These were things like the Freedmen's Bureau. And yet I have no doubt that the conservative originalist justices are going to abandon originalism so as to follow their conservative philosophy. And I think this chapter is important because what it says is that the conservative originalist justices say that they have a neutral methodology. They're not imposing their values. But that's not right. They're very much imposing their values and only following originalism gets to where they want to go. Maybe I can put it another way. In the last week of June of 2022, the Supreme Court said the government in some contexts is required to subsidize religious schools. The court said there's a very broad right to have guns, including in public concealed weapons. The court overruled Roe v. Wade and said there's no abortion right. The court said that a high school football coach has the First Amendment right to go on the field and pray. Unless you believe that the current Republican platform and the framers' intent are identical, what you see is the conservative justices coming to conservative results and then just justifying what they do in the language of originalism.
So after you go through these 5 categories of problems you identify with originalism, you have a chapter toward the end where you entitle it In Defense of Non-Originalism. And I think it would be helpful to all of us to hear you say, as a kind of introductory word, say something about the phenomenon of the formalists and then the legal realists who came after them.
This is important because it helps understand the debate over originalism in a very much broader context about legal reasoning. Through the 19th century, there was a belief that what judges should do is discover the natural law principles, the principles that are just out there, and then they should reason mechanically and apply those principles in a deductive way to come to determinate conclusions. The legal realists come along, and that's what they called themselves and were called by others in the early 20th century. And they said, that's all nonsense. There's no legal rules that are just out there to be discovered. All the legal rules are choices by judges, or the laws choices by legislators. In the 19th century, it was very difficult for an injured worker to be able to recover from the employer. And the legal realists said, that's because judges made rules to favor employers over employees. Very hard for consumers to win against merchants. That's not because there's some neutral rules out there. That's because judges made rules to favor merchants over consumers. And the court said there's no such thing as mechanical judging where judges don't have discretion. Inevitably, judges have discretion. What's an unreasonable search or seizure? What's cruel and unusual punishment? And the legal realists came forward and said, we have to look at judging as it's really done, not the idea of formalism. And we're all products of the legal realists. Very few people today believe that there are legal rules that are just out there for the judges to discover, or that formalism is possible. Interestingly, though, the originalists say they believe in formalism. Justice Scalia embraced the idea of formalism. And what I want to argue is that formalism was shown a century ago to be impossible. It's just as impossible today.
You say that throughout American history, the Supreme Court has rejected originalism.
Indeed, it has. Let me take an example, and this may get to the very last chapter. The Supreme Court, under the word liberty of the Due Process Clause, has protected the right to marry, the right to procreate, the right to custody of one's children, the right to keep the family together, the right of parents to control the upbringing of children, the right to purchase and use contraceptives, the right of competent adults to refuse medical care, the right of consenting adults to engage in same-sex sexual activity. None of those rights could be justified from an originalist perspective. And I could give many more examples. And as I quoted earlier, it was John Marshall who said, we must never forget it's a constitution we're expounding. Constitution may adapt and endure for ages to come. Originalism is a very new development. It really starts in the 1970s and comes into vogue on the court in the 1980s. And now with 3 Trump justices and the holdover justices, it's got its day in the Supreme Court. But throughout American history, the Supreme Court has rejected originalism.
So when we get to the discussion about originalism, you say does not yield determinate results, and you say admittedly non-originalism doesn't either. So I can envision a skeptic, an originalist, saying to you, you say the originalists are just doing what they want to do anyway. Will you admit that you non-originalists are also just doing what you want?
Absolutely. Let me take an easy example. The first case I ever argued in the Supreme Court involved a man who received a sentence of 50 years to life in prison for stealing $153 worth of videotapes. He received that sentence even though he'd never committed a serious or violent crime. He received that sentence even though prior to California's 3 strikes law, no one in the history of the United States had ever received a life sentence for shoplifting. The issue was, is that cruel and unusual punishment? You're not going to be able to answer that question by the language of the Constitution. You're not going to be able to answer the question by what was the original meaning in 1791. There wasn't a three strikes law in 1791. It's a value choice by the justices. Or let's take Brown versus Board of Education. It was a value choice by the Supreme Court that laws mandating segregation in education are unconstitutional. It was a value choice. And so, in answer to your question, yes, both originalist and non-originalist justices and judges have to make value choices. It's inevitable. There's no way around it.
Right. So this is the first answer of yours that I didn't see coming, because I would have thought that you would have said something about, for example, non-originalists who use a variety of tools to come up with interpretations of controversial constitutional clauses, but that it all begins with the preamble to the Constitution. And you don't write about the preamble in this book, but I've read where in one of your other books where you go on at some length about the significance of the preamble. And I think that your argument, which I'm going to ask you to share with our participants in a moment, but that the argument about the preamble as being a lens through which we have to interpret these clauses is very compelling.
I'm going to divide your question into two parts. One is, what are the things that a non-originalist looks at in interpreting the Constitution? The text, including the preamble, the structure of the Constitution, the original meaning and framers' intent to the extent which discovery can be looked to. It's not determinative. History and tradition, precedent, modern social needs. They don't lead to a determinate answer, but those are the things that courts have always looked to. I did write a book. It's how We the People, a progressive reading of the Constitution. And I say that the preamble tells us the values that the Constitution is meant to achieve: democratic governance, effective governance, liberty, justice, and it should, but it doesn't include equality. And I try in that book to describe what I think progressives should do in interpreting the Constitution to achieve those goals. But I'm not saying from an originalist perspective, you're going to come to the conclusions I am. I reject originalism. I just think we need to start with what are the goals we're trying to attain.
Yeah, I like that, and I think that I think it becomes part of an effective response to say we're not just making this up out of whole cloth, but we have some starting principles, the ones you identify from the preamble, and everything else has to be read or interpreted consistent with that. So in the chapter about the defense of non-originalism, you make three primary arguments. You've just touched on one of them. It's desirable to examine many different sources and considerations. Desirable that the Constitution be a living document, which I take to be in effect, if not intent, the response to Justice Scalia, who famously used to say, Constitution, it's not living, it's dead, dead, dead. Can you chat with us for a moment about that?
Justice Scalia said exactly that, and he said it frequently. And my view is the antithesis of that. My view is what John Marshall said when he said, we should never forget its Constitution meant to be adapted and endure for ages to come. It makes so little sense to say that we're going to be governed just by what those in 1787 or 1791 thought. It was a tiny country. It was largely agrarian. Half the states had enslaved persons. Why should their views be controlling? I think the only way it makes sense to be governed under a constitution written in 1787 is for it to be a document that's living, which means that the meaning is gained through interpretation, not just through an impossible amendment process.
So the final chapter you entitle, We Should Be Afraid. And it's now clear, of course, to those who are listening to this program, your book very much has a point of view. I've made a little effort to conceal I share that point of view, but I'm sure that we have some diversity of legal political philosophy among those who are listening. When you say we should be afraid, what's the argument?
I finished the manuscript for this book in the fall of 2021, and it takes about a year from then for it to come out. And yet, as I wrote the book in the summer and fall of 2021, I predicted that the Supreme Court was about to overrule Roe versus Wade. And of course, that happened on June 24th, 2022. I think that the point of this chapter is to say that following originalism would mean a radical change in constitutional law. Think of the rights that I've mentioned: the right to marry, Loving versus Virginia, that a state can't prohibit interracial marriage, Obergefell versus Hodges, that a state can't prohibit same-sex marriage, the right to procreate, states can't impose involuntary sterilization, the right to custody of one's children, the state can't, without a compelling need, terminate parental custody, the right to keep the family together, the right of parents to control the upbringing of their children, the right to purchase and use contraceptives, the right of competent adults to refuse medical care, even life-saving medical care, the right of consenting adults to engage in same-sex sexual activity. None of these can be justified from an originalist perspective. And so what worries me so much is how dramatically the law might change if you have a court that's following originalism.
I want to begin to wrap us up with my eye on the clock, Erwin, and I want to conclude by asking you two questions. And there have been some questions that have come through the chat, and I think that the questions I want to ask you will capture some, if not all of them. So the first question I want to ask you is about the past. Namely, in your view, is there something that non-originalists did or failed to do in the past that has led to this phenomenon of originalism gaining such credence in some parts of the judiciary?
I'm going to give a typical law professor answer. Yes and no. Yes, I think non-originalists are partially to blame. I think that non-originalists have never done a very good job of justifying non-originalism. Originalism is such a simple theory. The justice can say, we're not imposing our views. We're just following the original meaning of the Constitution. If you don't like it, amend it. I don't think non-originalists have done a very good job of defending non-originalism. But the no part of the answer is the rise of originalism is largely because of the coincidence of who's gotten to appoint Supreme Court justices. Between 1960 and 2020, Republican presidents served 32 years and Democratic presidents served 28 years. In 2024, it'll be even 32 and 32. But between 1960 and 2020, Republican presidents picked 15 justices, Democratic presidents picked 8 justices. Or to put it another way, Donald Trump picked 3 justices in 4 years. The prior 3 Democratic presidents, Carter, Clinton, Obama, served together 20 years, and in 20 years, they picked only 4 justices. I'll make it even more stark. If Hillary Clinton had won the presidency in 2016, and if she had picked the 3 justices to replace Scalia, Kennedy, and Ginsburg, we wouldn't be having this conversation. I wouldn't have written this book. The reality is that we'd have one true originalist on the Supreme Court, Clarence Thomas, and originalism would be relegated to his dissents and conservative law professors' law review articles. So the triumph of originalism is about who was able to put justices on the Supreme Court.
Which I think leads to my second question. If my first one was about the past, my second question is about the future. Namely, what in your view should non-originalists, people who share your views on this subject, what should they do with respect to the Supreme Court? For example, do you favor increasing the number of justices, or imposing term limits, or a legislative override of court decisions. What should one do if they share your view?
I have long favored term limits for Supreme Court justices. I wrote another book a few years earlier than the one we're talking about called The Case Against the Supreme Court. And in it, I argued for 18-year non-renewable terms. Some of it is that thankfully life expectancy is a lot longer now than it was in 1787. In 1787, average life expectancy was about 36 years old. Through much of American history, from 1787 to 1970, the average tenure on the Supreme Court was 15 years. Since 1970, it's 27 and a half years. It's just too much power in one person's hands for too long a period of time. Clarence Thomas was confirmed in 1991 at age 43. If he serves until he's 90, the age Justice Stevens left the court, he'll be a justice for 47 years. Amy Coney Barrett was 48 when she was confirmed in 2020 to replace Justice Ginsburg. If she serves until she's 87, the age Justice Ginsburg died, she'll be a justice in 2059. So I favor term limits. Expansion of the Supreme Court is a harder question. And though I would argue in favor of it, it's just not going to happen. It was not going to happen with the Republican House. And even when there was a Democratic-controlled House, the Republicans in the Senate would have filibustered. I don't favor congressional override of Supreme Court decisions. The idea that Congress could adopt a blatantly unconstitutional law and say no court can invalidate it is chilling to me. And this, of course, is the exact controversy going on in Israel now, where the Prime Minister Netanyahu has proposed giving the Knesset the ability to override the Israeli Supreme Court. And if I was in Israel, I would have joined the protests, including those yesterday, at the idea of the legislature being able to do something unconstitutional or illegal and immunize it from judicial review.
Erwin, I am going to have a very brief closing comment, but before we get to that, let me ask you the typical lawyer's question at the end of the deposition, which is there any question that I haven't asked you that I should have? Is there anything you'd like to say to our participants that somehow hasn't come up in our questions?
I'll say two quick things. One is your last question is so crucial. And my answer to it ultimately is it's so important that we get involved in elections. Elections have consequences of court. It's so important that we look to state courts to protect rights where the Supreme Court hasn't. It's so important that we look to Congress and state legislatures, city councils to protect rights. And it's so important we get involved in the organizations that are fighting for all of these things. The second thing that I would say is thank you. Thank you for having me on. This was such a wonderful conversation.
Appreciate that. My dear friends, a good OLLI program like religion and folk music should comfort the afflicted and afflict the comfortable. For those of you who are troubled by what you already knew of originalism, I hope Professor Chemerinsky's marshaling of the arguments gives you some comfort that you're now better equipped to respond to it. For those of you just learning about originalism or who are favorably inclined toward it, I hope at least this program has raised some questions for you. I am sure I speak for all of us when I offer our gratitude to the Dean of the Berkeley Law School for presiding for 1 hour over the Berkshire Law School. Sorry, I couldn't resist. Erwin, thank you. For a closing sermon, I cannot do better than to quote the concluding paragraph from the book, Worse Than Nothing. Professor Chemerinsky writes, "Now is the time to get past the debate over originalism and non-originalism and focus instead on a far more consequential question. What meaning for the words of the Constitution would advance the noblest goals of a modern, democratic, pluralistic society? And how should that meaning be applied in specific cases? The Constitution has always been and will always be about balancing the majority's values against the values that should be protected from society's majorities. This is what every Supreme Court opinion concerning the Constitution should be about, and what scholars and commentators on constitutional matters should consider first and last. Everything else is a distraction. To which I add, amen. Thank you, OLLI, for bringing us together. Thank you, Professor Chemerinsky, for teaching us. And thanks to all of you who share my romantic view of how to spend an hour on Valentine's Day. Wendy, happy Valentine's Day. I love you. And to the rest of you, I say, see you around campus. Thanks a lot. Good night.